witnesses, I call this meeting to order, acknowledging, first of all, that in Ottawa, we're meeting on the traditional unceded territory of the Algonquin people. Pursuant to Standing Order 1082 and the motion adopted on April 29, 2021, the committee is continuing its study of enforcement on First Nations reserves. To ensure an orderly meeting, best practices are participants, you may speak and listen in the official language of your choice. The bottom of your screen, the globe icon, you can select floor, English, or French. And as you present your testimony or answer questions, you can switch languages without having to touch that button again. When speaking, ensure your video is on and please speak slowly and clearly. When not speaking, your mic should be on mute. Now, pursuant to the motion adopted on March 9th, 2021, I must inform committee that as of 8 a.m. this morning, Robert Louis, Michael Anderson, Leroy Denny, and Doris Bill had not completed the technical pretest. So with us today for just under 2 hours by video conference are the following witnesses. And Chairman Robert Louis of the First Nations Lands Advisory Board, Chief Heidi Cook and Director Andrew Bainan of the First Nations Land Management Resource Center, Chief Leroy Denny of Eskasoni First Nation, Chief Doris Bill of Kwanlindun First Nation, and Chief Garrison Settee and Michael Anderson, Policing and Public Safety Advisor, representing Manitoba, Kiwatano, Okimakanak, Inc., MKO Inc., and I am informed that Chief Louis and Chief Cook are appearing jointly and will be splitting their 6-minute opening statement time. Accordingly, we will begin with them and go on through the rest of our witnesses. So, Chief Louis, you have the floor. Go ahead, 6 minutes.
I believe he's muted.
Chief Louis, can you unmute?
Yes, sorry. Good day, Mr. Chair and honorable committee members. I am Robert Louis, Chairman of the Lands Advisory Board, and my colleague is Andrew Bainan, who works in the First Nation Land Management Resource Center, who will also be presenting. We represent the First Nations, who are self-governing and pass laws under land codes. Some of our First Nations have been operational with lawmaking powers since the turn of the 2000 millennia, January 1, 2000. We have a serious problem with enforcement and recognition by the courts, RCMP, and policing authorities of land code law enforcement. Lawmaking and self-determination is meaningless without enforcement. Currently, there is a gap. We urge this committee to recommend immediate federal action to resolve this enforcement issues. The most important message to this committee is the need to solve the enforcement of First Nation laws crisis now, this year, not next year or years later, but now. This committee has heard about complexity, risks, funding, and resourcing, federal provincial considerations, and the need to build partnerships. The focus must turn to answers instead of questions. We urge this committee to sound the alarm by pointing out how much damage is being caused by the failure to enforce First Nation laws. First Nations are suffering harm because trespassing, family violence, illegal dumping, violations of COVID-19 restrictions, and other offenses are occurring right now, and there is no clear enforcement in place. Chief Rempel of Comox First Nation spoke with this committee about the challenges she has faced in dealing with trespassers. Other land code First Nations have had to deal with similar trespassing problems, including alleged drug dealers, bikers, homeless encampments, and residents of trailers without proper water and sewage hookups. Many land code First Nations have faced challenges with illegal dumping and difficulty controlling some environmentally harmful business on reserve. The framework agreement on First Nation land management has included matrimonial real property provisions for decades, but there are major and risky gaps in the enforcement system intended to protect spouses and children. Land Code First Nations have tried to control the COVID-19 pandemic on their lands. There has been nothing but failure on this front, with federal and RCMP officials suggesting that old colonial Indian Act bylaws should be used rather than land code authority. Federal officials do not seem to understand that many First Nations consider the Indian Act offensive. Land code First Nations are past the bylaw phase of the Indian Act. Land code laws are passed by the First Nation, not bylaws under the jurisdiction and legislation of the Indian Act. The crisis in enforcement of First Nation laws has consequences for all Canadians. The cost to clean up environmental damage is far more than prevention. Family violence has social costs far beyond individual families. Well-regulated communities contribute to economic prosperity. We urge this committee to call for a more serious and focused federal report. This committee has heard from 5 federal agencies. Who has a lead role in the federal bureaucracy for solving the enforcement of First Nations laws crisis? There is a circular firing squad of inaction in the bureaucracy. Questions are asked such as, what is the source of authority for police officers, and what about risk of liability? Too often, the bureaucracy has stopped at questions without driving to answers. We recommend the appointment of a special federal advisor to help lead the bureaucracy and report to this committee within the next 6 months. Canada's guidelines for enforcement of Indian Act COVID-19 bylaws excluded the Framers Agreement and self-government. In our view, this has accidentally sent a perverse message that only the Colonial Indian Act works. We urge this committee to call for federal provincial solutions. We are seeking to prosecute offenses in the provincial courts. The committee should call on federal experts to advise within the next 6 months on what is needed to unlock provincial cooperation. Federal provincial discussions will inevitably raise funding concerns, but this should not delay figuring out how to make this work. Funding. Federal funding for Land Code First Nations has increased over the years, but there is still not enough funding to support an adequate enforcement system comparable to other governments in Canada. Funding for enforcement of Land Code laws should be looked at and increased. Land Code First Nations understand federal provincial concerns over resources and funding. We also want an effective and low-cost system, and we will work hard to achieve that. Conclusion. Several Land Code First Nations are pursuing pilot projects which we hope will be major successes in the near future. Committee members may be interested in registering at www.indigenousenforcement.com for tomorrow's May 26th discussion of a pilot project led by the Muscadet and Whitecap First Nations in Saskatchewan. Thank you for your consideration, Honourable Committee. I will be pleased to answer any questions the committee may have at your leisure.
Thank you. Thanks so much, Chief. Chief Cook, were you going to add on to Chief Louis' presentation?
Good morning. Apologies, I had a mix-up on the time zone. Thanks for the invitation to share.
I'm sorry, Chief. I don't think we can hear properly. Mr. Chair, we have a sound issue, technical issue with Chief Cook.
I'll have some people get in touch to make sure that the device is set up, but we won't be able to proceed with the audio as is.
Okay, so Chief Cook will get you sorted out. In the meantime, we'll move on to, for 6 minutes, to Chief Leroy Denny. Chief, go ahead for 6 minutes.
Yes, good morning. My name is Chief Denny, and it is my pleasure to join you from here, from Eskasoni First Nation community. Sunny day here in the beautiful territory of Mi'kma'ki, and located here on east coast of Canada. Eskasoni is the largest Mi'kmaq community of population of almost 400 to 700 people. My name is Chief Leroy Denny, and I am the chief of the community of Eskasoni, and I thank you for the invitation to appear before your committee on the motion to study enforcement on First Nation reserves. I was born and raised here in Eskasoni, here in my community. And my grandfather was also chief of my community, and also my godfather was a Vietnam vet and a police chief for Eskasoni for many years, and one of the key people who police and started here in Eskasoni, from police department into Unama'ki Tribal Police, which I'm going to talk about. I'm here to address how the current policing practices and enforcement on First Nation communities. There is no denial that the impacts of colonialism continue to reverberate in all of our Indigenous communities across the country. Sources of conflict regarding the cost of police non-reserve remains a source of conflict requiring resolution. Canada's position to hold police non-reserve as a joint responsibility with the provinces has created a jurisdictional confusion that results in inefficient and under-resourced policing, where our community members are the ones who suffer in the day. And a special constable program continued on the First Nation communities throughout the Nova Scotia in the 70s. In a program that was underfunded and under-resourced. Since this time, because of these issues, the Mi'kmaq lobbied for control over policing in their communities. As a response to the Royal Commission of Aboriginal Peoples, the Donald Marshall Inquiry, the Unama'ki Tribal Police was created in 1994 under the umbrella of the federal First Nation policing policy to provide policing to all 5 Mi'kmaq communities, and which in Cape Breton, which are Eskazoni, Membertou, Bottleneck, Wegahoma, and Wamunku. And I was a former employee as a jail guard and also part-time dispatcher at the time, which was really young when one of my first jobs. But attaining control over our policing was a key component in achieving self-determination and enhancing control of enforcement in our communities. This was a decolonized method of offering police services where cultural methodology was used in implementing community policing methods to resolve problems and promote community healing and trust, used in our language. In the late 90s and the early 2000s, this essential program was defunded, and RCMP established the community and Aboriginal and diversity policing services to serve First Nation communities. Presently, we have RCMP serving our community. I commend their efforts and in policing our community because we have some Mi'kmaq police that are in the force. Whereas my own brother served both as Unama'ki police and RCMP for our community, which is now just retired a couple months ago. However, as a leader in a community member, I cannot help but see the injustices that we continue to face in not only becoming self-determined, but also for our health and safety of on-reserve. When the global pandemic hit last year, there was a directive that the police in Indigenous communities and the judiciary will assist Indigenous communities to enforcing their COVID bylaws, which is the lockdowns we have. However, the reality was not this. And what happened was they didn't respect our bylaws. We had our own curfews. We had our own lockdowns. They weren't respected. And we had our own restrictions. And we had issues with the police. I end up calling my MP and to the top office to make sure our bylaws are respected, but it wasn't. It was very difficult for us for security and to control, to make sure the lockdown to keep COVID out. This issue also hinders our ability for the enforcement of laws made on reserve. Bylaws are not respected and are honored by current policing authorities. It makes becoming self-determined within our communities difficult. It was very difficult. Before I end my submission to the committee today, I would like to discuss the issue of health and safety on reserve and policing. Due to personal experience, I can attest to the issue we face regarding this issue. In just end of February 28th, one of my directors, CEO for Crane Cove Seafoods, was shot. My neighbor, also my family member, my first cousin, was shot next door, and to this day we don't know who shot him. And he the first person he called was me because I was next door down the road. He called me and I called 911, and there was a sound of distress on the phone that he was being shot, 2 shots. My family, we all heard gunshots here. I was on 911 for at least good 4 minutes, and I got there. 911 told me not to go in, but it was my friend, my family member was in distress, so I had to go in. And it was already 10 minutes. And still waiting for the police, still waiting for the paramedics. and I had to go in, and God knows, I didn't know if there was any shooter there, but I had to sacrifice my own life to save my family member. So after 20 minutes, I had to take him to my vehicle and drive him to the ambulance station. And there were no police yet. To this day, but I don't know why. So I'm still dealing with trauma, and there was a lot of blood, and I had to deal with. Luckily, he survived. He's recovering, but after 30 minutes, I counted the minutes when I did my statement. After 30 minutes, police already just end up going to the house to start an investigation. It was poorly done, and I had to, he relied on the police, the paramedics. He relied on me. I was the first person to get there. I took in the ambulance. That shouldn't be it. Community members shouldn't be doing that. And saving lives of a line of fire is the police. We rely on the police, and we were trusted. That's in agreements. I shouldn't be doing it. It should be them. I'm still have a lot of questions for that, and it's at the end of it. So I'll end right there.
Okay. Thanks, Chief. Thank you very much for your testimony. We go now. I see there's Chief Cook. I believe she's still working technically, Mr. Clerk. Okay, so we'll go to Chief Doris Bill from Kwanlin Dun First Nation. Please go ahead.
Good morning, everyone, and thank you for the invite to be part of this important conversation, and I hope you are all well. My name is Doris Bill, and I am Chief of the Kwanlin Dun First Nation. We are a self-governing First Nation, an urban First Nation. Our traditional territory is located in and around the city of Whitehorse, Yukon. We settled our self-government and final agreement 16 years ago in 2005. These modern treaties empower us to manage our settlement lands, to enact legislation, and to make our own decisions in the best interests of our citizens, to be self-determining. I am here today to share some information about our First Nation and our journey to create a collaborative, community-driven approach to addressing safety, support, and enforcement in our traditional territory. Many Indigenous people and Indigenous communities in Canada have a complicated relationship with the RCMP. Our First Nation is no different. History has made it difficult to trust. People sometimes need to be reminded that the police were involved in the trauma that came with residential schools, the 60s scoop, and forced relocations of our people. These events are still a part of our people's living memory, and that trauma continues to be passed down through generations. We cannot change the past, but we can look forward to a brighter future, one where we can work together for mutual benefit. I do not support recent calls to defund policing services. Here at home, I am sure our police department could use additional resources. In some cases, increased demands and inadequate resources have had a trickle-down effect, especially as it relates to prioritized calls and response times. At one point, citizens reported that at times it would take an hour or more for officers to show up, and there were matters where no officers attended at all. To provide some insight into where I am coming from, as a former journalist, I am aware of the crime in our area, but the reality of the situation truly hit home when there were 2 murders in our community shortly after I was elected in 2014. These tragedies struck at the very core of our people, and they were a catalyst for change. The first step towards healing is to admit that there is a problem. In our case, we chose to listen, learn from one another, and put what we heard into action. Through many discussions, we learned of numerous break-ins and other crimes in our area. We saw that most of the violent crimes were committed by people who didn't belong in our community. We heard from single moms who were sleeping with baseball bats beside their beds, from elders who didn't feel safe going out for a walk, from citizens concerned with bootlegging and drug houses, and from parents wanting reassurance that their children would be safe playing outside in the neighborhood. So together, under the community's direction, we created a comprehensive community safety plan, establish an interagency working group of partners, including the RCMP, bylaw services, SCAN, Public Safety and Investigation and Correction Services Canada, and built an innovative Community Safety Officer or CSO program, which launched in 2016. It is the CSO program I wish to highlight today. The program is centered on the concept that the safety, health, and well-being of Kwanlindun citizens would be significantly enhanced through the intensive and consistent presence of safety officers who come from the community itself. So, all of the 4 full-time and 2 on-call CSOs that work on our lands are citizens or have a strong connection to the community. CSOs help mediate disputes, they provide safe rides to safe places, and they connect citizens to other services like RCMP, family and child supports, and legal services when needed. They patrol our streets, they are visible, and they are known. They do not replace RCMP or any other service in our community. We understand the value and need for policing, bylaw, and other government services from partner organizations. But the CSOs help to bridge the gap between our citizens and those necessary services. And they help our citizens to achieve better outcomes from their interactions with those services. In fact, it is the strength of our partnerships that make this program possible and successful. The support we receive from the Yukon government, Canada, and RCMP is essential. And we have seen that it is working. Kwanlindun is proud of this program and how citizens and elders report feeling safer with the CSO on patrol. We see fewer calls to RCMP so they can focus on dealing with the things they really should be dealing with. We remain committed to the process of building community-driven, culturally relevant services for our citizens. Another step forward came last summer when we signed a historic letter of expression with RCMP. It promotes positive and cooperative relationships and defines policing priorities, goals, and strategies that are specific to the needs of Kwanlindun. I won't say it has been an easy process, but it has been extremely rewarding for our community as a whole. Ultimately, it is about choosing a path forward where strong partnerships allow us to create and steer the kind of policing we know we need in our community. I think we can agree together we can bring about change. Shoni Thun, Gunas Chis Masicho, and thank you. I welcome your questions.
Thank you very much, Chief Bill. And we'll go to Chief Sethi and Michael Anderson together. Chief Garrison Sethi, 6 minutes. Go ahead, please.
Tansei, bonjour, Atlanite. On behalf of the MKO First Nations, we have 26 First Nations under our administration and at least 73,000 people. So I am pleased to have the opportunity to share with the committee some of MKO's views on enforcement on First Nation reserves. I will also be making a few references to the MKO book of documents that MKO has provided for the assistance of the committee. And with the help of Mike Anderson, MKO has 7 key points. First, Indian Act bylaws under Section 81.1 and 85.1 of the Indian Act are federal regulations under Section 2 of the Interpretation Act. Section 2A of the Statutory Instruments Act, and Section 7L of the Statutory Instruments Regulation. The BC Court of Appeal has confirmed this at paragraph 12 of its 1987 decision in R.V. Jimmy. Second, and most fundamentally, Canada has failed in its duty to enforce and prosecute these valid laws of Canada. First Nation bylaws under Section 81.1 and Section 85.1 of the Indian Act have not been enforced by policing authorities or prosecuted for 25 years in Manitoba. This is a quarter of a century. The protocol relating to the enforcement and prosecution of bylaws adopted pursuant to Section 81 and 85.1 of the Indian Act mentioned by the government witnesses before this committee confirms that the Indian Act bylaws are not being enforced or prosecuted in Manitoba. Except for the 11 very recent protocol agreements, this has been the case across Canada. Particularly in remote First Nations communities served by periodic RCMP patrols, communities are in crisis due to the uncontrolled bootlegging and drug dealing fueled by long-term non-enforcement of Section 85.1 bylaws. Communities are also unable to see or ensure that COVID-related emergency measures are being enforced by police and that charges are being laid and offenses are being prosecuted. This is no deterrence and compliance is undermined. Third, we are making some important progress after a concerted months-long campaign carried out jointly with the Lands Advisory Board, the Lands Advisory Board Resource Center, and the Manitoba Public Interest Law Center. MKO has been working with the Public Prosecution Service of Canada and the commanding officer of RCMP D Division to develop and support operationalizing a protocol that can be applied by all 26 First Nations in our territory. The protocol applies only to the enforcement of prosecution of Indian Act bylaws in response to the COVID-19 pandemic. The protocol is not long-term. It's not a long-term fix of enforcement and prosecution issues. The Manitoba Department of Justice very recently committed to adopt an MKO recommendation to revise 2021-2022 First Nation Safety Officer programming. These amendments will include recognition that FNSOs have peace officer powers when enforcing all Section 81.1 and 85.1 Indian Act bylaws. These revisions to the FNSO operating agreements are important to clarify the powers of FNSOs when enforcing COVID-19 related bylaws under the protocol. Mr. Anderson, please.
Yes. Fourth, although we've made some progress regarding the recognition, respect, enforcement, and prosecution of banned bylaws, First Nation Land Management Act laws have not been enforced by policing authorities or prosecuted by Crown prosecutors for 20 years since the coming into force of Bill C-49 in 1999. As to the enforcement of land code emergency laws, the RCMP says, the RCMP recognizes First Nation authority under the FNLMA. However, there are concerns whether the FNLMA land codes provide legal authority to enact COVID-19 related laws. See documents page 13. ISC says, I appreciate the frustration of First Nations who have taken on such fundamental aspects of their governance through the enactment of a land code, only to be forced to rely on Indian Act authorities. See the MKO Book of Documents, page 16. Public Prosecution Service of Canada says the role of PPSC set out in the Director of Public Prosecutions Act is inapplicable to FNLMA land codes and FNLMA First Nation laws. Fifth, there's a harmful uncertainty related to the appointment and empowerment of First Nation safety officers to act as peace officers. Simply put, you have to be a peace officer to stop, search, seize, and detain. And you need those four powers in order to effectively enforce First Nation bylaws under Section 81 and 85.1 of the Indian Act. Sixth, PPSC and the RCMP do not accept the validity of Indian Act bylaws enacted after December 15, 2014. Parliament repealed the ministerial power of disallowance and approval of Indian Act bylaws effective December 15, 2014, with the coming into force of Bill C-428. However, as PPSC witnesses have advised this committee and MKO, PPSC will not recognize the validity of bylaws enacted on or after December 16th, 2014, unless reviewed by an appropriate federal government department. However, PPSC, Indigenous Services Canada, and RCMP have each advised this committee and MKO that they will not review bylaws enacted after December 15th, 2014. Therefore, there is no such federal department which will review existing Indian Act bylaws enacted after December 15th, 2014. This means that the protocol will not apply to any existing post-Bill C-428 bylaws, including those health and safety bylaws and their related health orders, which have been specifically enacted to address the COVID-19 pandemic. PPSC's acceptance of MKO's proposal to conduct a third-party review, along with the Public Interest Law Center, appears to be the principal, if not the only pathway to ensuring that the protocol will apply to the existing First Nation COVID-19 emergency laws in the MKO region. And then seventh, the gaps uncovered by the COVID-19 pandemic, including those highlighted in evidence recently presented to this committee, reveal that the legislative framework, the federal civil service and policing authorities are incapable of supporting or unwilling to support the exercise of First Nation self-determination and lawmaking powers enacted by Parliament through Bill C-428 and the First Nation Land Management Act. And Grand Chief Settee has a concluding comment.
Well, we're at 7.5 minutes. If we can just stop it there, and hopefully more points will come out through the rounds of questioning. It's so important that we get our committee members responding to the statements. So, Mr. Clerk, how is Chief Cook doing technically?
Better, I hope. What I'll ask Chief Cook to do is introduce themselves and say where they're testifying from, and then interpretation will let me know if we can proceed with testimony.
Good morning, Chief Heidi Cook. I am in Mississippi Cree Nation, Treaty 5. Was that good?
I hope so, Chief Cook. I'm just going to wait for feedback. It'll be just a moment.
I see a thumbs up.
Yes, we can proceed, Mr. Chair.
Well, Chief Cook, thanks so much. Sorry about the technical issues, but we do want to hear your testimony. For 6 minutes, please go ahead.
Thank you for the invitation to share on behalf of the Mississippi Cree Nation. As I mentioned, we're signatories to Treaty 5. I would like to describe our experience with the COVID-19 pandemic and our difficulties enforcing our land code law. From the beginning of the pandemic, MCN regularly enacted measures over and above the provincial health orders, including closing our VLTs, putting up a highway check stop, and introducing mandatory isolation for non-essential travel, capacity limits in our businesses, hand sanitizing stations, and mask mandates. At our checkpoint on Highway 6, we monitored non-essential travel into northern Manitoba. And at first, we benefited from the perception that the checkpoint was tied to the enforcement of provincial northern travel restrictions. In reality, our First Nation safety officer had no ability to ticket anyone on the provincial highway when they would pull off onto the reserve for gas or a break. He would provide some warnings to travelers, but the checkpoint eventually became very hard to operate because people realized it was the band doing it and not the province. And we started to get a lot more dangerous driving complaints and racist insults directed towards our workers. And eventually we just had to take it down. We enacted our first public health order on October 20th, 2020, and then our land code COVID emergency law on November 5th, 2020. Our public health orders pursuant to that law included controlling non-essential travel and requiring isolation, putting in gathering and occupancy limits in public and private locations on reserve. Our first wave was in October and November of 2020, and we maxed at 4 cases. During our second wave, which started in January 2021 and extended into February 2021, we needed help enforcing some public health orders, and it wasn't forthcoming. People started to know that the RCMP would not do anything to help, and so they were much more brazen in defying the public health orders. We could have had help from the RCMP by using the drunk tank, using laws that they could enforce to stop people. In some cases, positive cases, we're going house to house looking for a party or a bed. We could have used some RCMP presence on our roads and at the checkpoint just to show support for our curfew and our lockdown measures. The lack of support from the RCMP, it got so ridiculous that one of our nurses went to a home to do contact tracing and found herself interrupting a domestic dispute where a woman was being beat up. And the RCMP did not respond because they said it was a public health matter and they wouldn't respond. Our safety officer attended, and only when the second call came in with information, I guess, from somebody who wasn't in the middle of the situation, then they responded. During that time, what was expressed by members of our pandemic emergency response team, our health team, and our enforcement team was that we felt abandoned and we were struggling to control the spread. Our second wave reached 155 cases and close to 300 contacts. We all suffered personal fallout, and I feel that we all have PTSD from the situation that we found ourselves in. We have not enacted any laws after the expiry of our emergency law. The decision was basically, what good is the law if it's not enforceable? So we haven't done anything since then. We're now starting our third wave. This time it's a UK variant, and we might exceed our second wave. It's in our school and our daycares already, and contact tracing or contact chasing is underway. And if we do better this time, I feel it will be due to our vaccination efforts and not necessarily the enforcement of our laws. I will end it there. Thank you very much for listening.
Well, thank you very much, Chief, and thank you to all our witnesses. And now we're going to go to our rounds of questioning. The first 6-minute round, we will have Gary Vidal, Jaime Batiste, Sylvie Beoube, and Rachel Blaney. Gary Vidal, please go ahead, 6 minutes.
Thank you, Mr. Chair. And I wanted to start by thanking all our witnesses today for your excellent testimony. It's going to help us as we formulate some recommendations, that will come out of our report on this whole study. I want to start with Chief Bill this morning. Chief Bill, I don't know if you remember, but I had the privilege of participating in a public safety committee meetings last summer when you were there, and I remember some of your testimony then very specifically. And I want to follow up a little bit on what we talked about last July and also some of your comments today. First of all, with your community safety plan and specifically the community safety officer program, I know you spoke of that last summer, and again, you spoke of it very highly today, where you were elected in 2014, you identified an issue, you listened to people, and you started to act, and you created some pretty significant partnerships by the sound of it. And one of the outcomes was this community safety officer program, which now by 2016, you said consists of 4 full-time, 2 part-time members. I want you to maybe just share a little bit more. It sounds like a real solution to potentially the issue. I know I experienced this myself as the mayor of a small city. I know the First Nation next to my community has begun that journey as well. It seems like an option to create some really significant solutions. And I would just be curious for you to expand on the journey a little bit from 2014 to 2016 and how you got to the place where you enacted that CSO program.
Well, thank you for the question. Yes, we developed the program after the murders of several people in our community. It really plunged our community into a crisis, and we realized and understood that we needed something a lot more. And the circumstances I described of people feeling not safe, it was, you could just see all of the issues bubble to the surface during that time. Issues that had been there for a long time, but just were below the surface. And when we built the program, we built it after many months and months of conversations with our citizens. And the program really came out of when we put people out there in the community just to keep an eye on the community, our people said they felt safe. And that's where it really started to take off. The conversations that we had with our citizens really helped guide the program. In addition to the safety officer program, we also focused on the infrastructure in our community. We would clear trails for line of sight, for safety. We improved lighting on our buildings. We improved the infrastructure in our community, which had been neglected for a long time. And we went to work building relationships and partnerships that really helped us to deal with some of the issues in our community. The relationship with the RCMP was not a good one. And we realized that had to change. And, today I can say that, I have one officer here, for instance, who had been here many years ago prior to the community safety program. And he said the change is just unbelievable. And, people drive through our community now and they say they actually feel the difference. It's not just seeing the difference, they feel it. And there's so many good things that have come out of this. I mean, one of the we just recently completed an evaluation, and that evaluation has really documented evidence that it has saved money, both in calls to service and from even from the bylaw end. And, we just keep working to improve it and improving the relationships that we have. And, it's a program, though, I just want to point out, it's a program, though, that is tailored to the community. Each community is different. And, you can, it may look a bit different in other communities, but I do know we've been contacted from First Nations across the country about this program. And, I wish we could help. We're only a small nation compared to some of the others I've heard on this call.
Chief, thank you. By you participating here and sharing your experience, you can help many others. So I'm gonna encourage you to keep speaking. The chair is going to cut me off very quickly, so I'm going to ask a real quick question here. We've talked a lot about kind of jurisdictional challenges as we talk about building relationships and finding solutions. You seem to have found your way through some of that with the partnership with the territory and the federal government and your own self-governing urban First Nation. Can you just quickly talk about some of the key things you learned about actually overcoming the jurisdictional issue and building those partnerships with the many people you talked about?
Well, it starts by building those partnerships and really, creating space for the program. For example, we have our traditional territories spreads throughout the city, and we sat down with the city of Whitehorse. We created an intergovernmental forum where we meet formally with the city of Whitehorse. We also sit down with the Yukon government, and we have those conversations and work out any problems or issues that we have. We've, because of our successes here in Whitehorse, we have the city of Whitehorse, the larger city of Whitehorse, asking for us to extend our program within the city. And okay.
I'm sorry about that.
That's okay.
We have lots of questions to come, and maybe on the same theme. Mr. Batiste, 6 minutes.
Thank you, Mr. Chair, and I'd like to start off my questioning with Chief Denny. Thank you for joining us, and thank you for your testimony. As you had mentioned in your testimony that the Unama'ki Tribal Police operated between 1994 and 2000, and it was one of the remedies or it was one of the recommendations from the Donald Marshall Jr. inquiry that looked at racism within the justice system. But I'm wondering if you could tell us a little bit about what you felt, were some of the successes around the tribal police or the challenges, but also over the last 20 years, it's been under the RCMP. So I'm wondering if you can tell us, in your view, how do you believe that the local policing has changed on reserve since the RCMPs took over? If you could just elaborate about what you've experienced in that time.
Yes, I know firsthand as a former employee for the Unama'ki Tribal Police, as a jail guard. I was a young man, and also dispatch. So I did witness a lot of good things that when we used to have a Unama'ki Tribal Police, majority of the force were Mi'kmaq officers. Before the Tribal Police started, there were over 10 Mi'kmaq officers. Mi'kmaq speaking officers were sent to Depot in Regina to train under the RCMP. They came back to in Unama'ki, and we policed all 5 Mi'kmaq communities. It was very, very underfunded and lack of resources they were dealing with. But the good thing about having our own Mi'kmaq speaking officers played a large role in community policing, and we indigenized and we decolonized our policing that time. But after years of lack of funding and we covered 5 bands, and they were just exhausted. We exhausted our police officers. We ended up picking up partners with the provincial police at that time, and then finally, the funding didn't pick up. It was less and less, and then we had to go to this new approach with the RCMP, and since then, we never had any new Mi'kmaq officers. It just stopped. Now, all the Mi'kmaq speaking officers that coming from Unama'ki and joined with the RCMP, they're all starting to retire, and as one of them is my brother Walter. And while they were in the beat, meaning while they were like doing the calls and going to the incidents, major incidents that happened, the Mi'kmaq officers played a large role, talking Mi'kmaq, being there and visiting elders. And they were doing all these things. They were visiting elders, they're involved in community events. That doesn't happen anymore. We don't know these officers. I've been pushing for Indigenous officers, at least, and Mi'kmaq speaking officers anywhere in the country. I want Indigenous officers in my community. Doesn't matter if Mi'kmaq or any other Indigenous person. It's really hard to find. And many Mi'kmaq youth been trying to get in police, and they're just denied and they fail. And I'm wondering why are they're not able to, their submissions are not being respected or approved to enter into policing, while these 10 Mi'kmaq officers plus 2 others were able to enter. But right now we're having a lot of issues. Our Mi'kmaq youth are not being accepted in the policing. So now most of our Mi'kmaq officers are retired. We're not going to have any more Mi'kmaq speaking officers, and to me that's a big issue. We need more Indigenous officers, especially those who speak their own language. That's the most crucial and most important thing that we need here. And if we want to indigenize policing, I really want to return Indigenous policing in our communities. We're the only ones. We know our people. We know exactly how to diffuse. We know exactly how our people, we have anger issues, language issues. We can, just by as a witness, I always witnessed how our Indigenous officers diffuse situation without any violence, without any weapons or tasers or pepper sprays, stuff like that, just using our language and the way we just understand. We know their background, we know their families, and we were able to already understand the background when they deal with the individual. That's really important, and we need our own Indigenous officers to be respected and help and find many ways to get them through this program. That's what we need right now. The colonized RCMP is so colonized now. That's why our Mi'kmaq officers can't get in there, because we don't meet the requirements. Our Indigenous ideology should be respected, and and I think that's the approach that we need to take. Thank you.
Okay, Chief, I think I only have time for one short question, but you put in significant measures to protect your community during the first phase of COVID. What was the experience like with the RCMP in terms of helping you enforce some of the laws that you created to keep your community safe from COVID in the first wave? Can you give us a sense of what the RCMP told you?
When we had our own lockdown, RCMP didn't want to get involved, and they kept saying, we're violating rights because we had a curfew and we locked our community down because there were a lot of cases around in town area. So we did a lockdown by using our health and safety bylaw, and the RCMP didn't work with us. We had to. Our poor security guards were policing it, and they were getting stressed out. They were getting, they're being after, and they were going after them. The police didn't do anything. They wouldn't do very similar from the chief that mentioned there earlier, how they didn't really play a role, and they said we can't use these bylaws because it was violating rights of people to enter, and they didn't want to touch it. So because I kept asking emails. Finally, the top officer, even the minister, that said we need our people. We need the RCMP to work with my people, with our security guards, to keep people safe. This is a pandemic. This is a deadly pandemic happening in our community. We're trying to protect our people, and you're not helping. Once this COVID hits our community, it's gonna, because of the high number of health issues we have in our communities, it's just going to affect many of our community members, like happened to many other First Nations across the country that COVID hit, and there were a lot of deaths happening. And that's one of the main reasons I'm really upset about to this day.
Chief, we better leave it there at 7 minutes, and we go to Madame Berube, s'il vous plaît.
Thank you so much, Mr. Chair. I am on the Cree Anishinaabe territory in Quebec. My question is for the First Nation Advisory Board. Mr. Louis, in your brief, you say that for policing, a lot of First Nation have a land code, and police forces said no when they did ask for some help. So can you give us some concrete examples of this kind of situation and tell us what were the impacts of these refusal for the First Nations communities? Chief? You're on mute, Chief.
If it's to me, I'm afraid it was all in French. I did not understand the question. I'm sorry, I don't know how to put it into English.
Okay, Mr. Louis, on your screen, on the bottom center is a globe. And you touch that, select the globe and select English. And then you will hear the translation in French.
Thank
you. So, Madame Berube? Cool.
Merci, Monsieur le Président.
Thank you, Mr. Chair. The question is for Mr. Louis. In your brief, you wrote that when it's concerning policing, a lot of First Nations with a land code didn't get any help from the police when they asked for it. So can you give the committee examples, concrete examples of this kind of situation, and tell us what were the impacts of these refusals on First Nations communities?
Thank you. Thank you very much, honorable committee member. We did have these examples. I guess the most prevalent is Chief Heidi Cook. She has a community with a land code, and I believe you heard some of her testimony. And that was a prime example that really started the spark that the RCMP would not acknowledge our laws. And that was a serious matter. We also have the Comox situation took place a few years ago, whereby they had a unwanted trespasser on their lands. They had their laws in place and wanted the eviction, and they called upon the local RCMP to assist in that eviction. They refused. They went into court, and there were difficulties with court in prosecution. The end result was that the community had to go to private prosecution for the unwanted trespasser. Eventually, the unwanted trespasser was dealt with through the prosecution. However, that process was very, very expensive. Private prosecution cost them in or about $178,000, and it is something that is far too costly to continue, albeit much of that cost was attributed to the court to understand the meanings of a land code, understand what it's about, all of the background, the history. In the future, private prosecutions, I think, can be reduced quite significantly, but it's an example of what needs to be done. There has to be education, training in the court system. There has to be understanding with the RCMP that these are federal laws that are being passed. The federal laws are equal to that of the federal government, and they're paramount, and they have to be recognized. So these are two very valid experiences that we've encountered. Thank you for your question.
J'ai une autre question pour vous.
I have another question for you. What are the benefits for the First Nations to have their own police force for maintaining the peace?
Significant. I think the benefits would be significant in the sense that we would have a system whereby the community would rely on their own policing system. However, the problem with that, of course, is the cost, and you've heard from the chief that gave testimony, of course, and the costs there are prohibitive. In my community, I was the chief of my community for 24 plus years, and during my term as chief, we explored setting up our own policing department. We came very close to having it implemented. The biggest problem was the costing of it and how do we properly run it. And after we examined all of the requirements of setting up that police force, we decided that it was just too prohibitive. Today, if I were faced again with that situation, I think that our own police force would have been instituted. We would have set that up. There's all kinds of issues with training, and that's costly, carrying sidearms and having the police and the authorities, the justice system agreeing that sidearms can be carried. However, in hindsight, with proper funding and the will of the people, we would have set up our own police force. I think in the long run, I agree that having community members involved in the policing system is a huge benefit. And I think people, look more towards prevention as opposed to the actual punishment and the appearance of police officers. Having said that, we do have good relationships here, and I think much of the relationships depends between community and community with police forces and how they deal with the community. So relationship is very important. It's always a struggle. It's always a part of the process to keep up those relationships. I think with better relationships, you have more improved services and a better community protection. In our case, I think that we need to work on more of a adjudicative system, not only with the courts, but having enforcement and having peace officers or enforcement officers having the authority and the power to implement what they need to do, so that there is no misunderstanding as to their authorities and their powers.
I'm sorry, members of the committee, I think my internet disappeared, and we're now past that time, and time for Rachel Blaney's 6 minutes. Rachel, please go ahead.
Thank you, Chair, and I want to thank all the witnesses. And I also had a weird internet moment there as well, Chair, so maybe it was just something that was happening in the system. My first question is to Mr. Louie. I really appreciate your testimony. You actually talked about this as a crisis of enforcement, I think is what you said in your initial statement. And that one of the concerning parts for you is that the Colonial Indian Act seems to be what is being promoted as the only thing that works. And of course, that undermines self-determination, Aboriginal rights and title, and so forth. So I'm just wondering, you said also that we need answers instead of more questions, and that there's some good pilot projects that are happening. I'm just wondering if you could tell us anything about good steps forward that we should hear about, that we could add to our recommendations in this report. Thank you. I think you're on mute.
I apologize to keep missing that. Sorry. Thank you very much again, Ms. Blaney, for your question. Yes, we do have some things that are happening that are positive, and I think that the positiveness is the willingness by provinces, territorial governments, and the federal government to listen and to really want to work on some solutions. We've started that situation with MKO in Manitoba. The attorney generals and those that are in charge of the various ministries have been active. We have a situation that's taken place, a pilot project taking place in Saskatchewan with the Muscadet community in Whitecap. That's working now with the Saskatchewan Attorney General's offices to look at how there can be better enforcement. We are hoping that these discussions will lead to an understanding by the province of Saskatchewan that they will recognize First Nation land code laws and recognize that enforcement is a joint process, that there needs to be collaboration and support of that. I think if we can do that there, we can do that in Manitoba, we can do that in Alberta, British Columbia, right through the country. I think this is where we need to be at. And so I think the discussions are happening right now. I think this committee and the recommendations that you would make, hopefully, they're going to be pressing, and the recommendations will say and hopefully support that this has to be done now. We cannot afford to wait. The laws that are taking place are being done now. We have laws in force. We are a government. I recognize as a government, we have the authorities and the powers of government, yet the laws are not being recognized and enforced. And we cannot wait for this. We have matrimonial issues, we have trespass issues, we have pollution of contaminants and matters of such great importance, they have to be dealt with now. So the more that this is understood, the more collaboration that takes place, and the more direction that this committee can give towards the various provinces, to all the ministries, that this is such an important matter, I think we're going to find solutions much, much quicker. So much appreciated with your question and this committee's work. Thank you.
Thank you. Thank you so much. If I could come to you, Chief Cook, you know, what we've heard in previous testimony is how self-determination is so important, but the lack of enforcement is really limiting the access to that, and that it has a big impact on leadership to have the ability to lead. And I think you just talked about it so well. You said that you're in the third wave, and I'm really sorry to hear about the impacts on your community and how stressful that is for leadership and for all the workers there. But you've made the choice to not do any laws or have any public health care announcements because there's absolutely no ability to enforce. I'm just wondering, how does that impact the ability of leadership to do their job? And what does it do in the community in terms of having consequences for behaviors that are not helpful?
I think the hardest part is not having consequences. We rely on our experience in the second wave to try and curb behaviors now. We think that most people have we've gone through a lockdown together and experienced an outbreak, and we hope that most people will just govern themselves accordingly, I suppose. It's very difficult to have also demands on people, like people asking leadership to lock down and to do things that they know worked. But we're just so difficult to manage that I'm not sure that we can do it again based on how much we struggled the second time. I'm not sure how many people are willing to put themselves through that, knowing what we know about what is required.
Well, and you also talked about the RCMP not being able to enforce and then trying to find ways to make the rules you were trying to enforce fit into RCMP enforceable rules. Just wondering about that very strange way of trying to govern.
Well, basically we needed help, and we were told that the public health orders that the ban passed, the land code law that the ban passed, none of it was enforceable. But that there was provincial public health orders, there was simple acts like driving around rather than sitting in the station all day that could have helped, create the perception that things were being monitored or enforced without the RCMP actually having to enforce them. So there was things like that we asked for and weren't as forthcoming as we felt that they could be. It did have an impact on the spread of COVID-19 in the community. It spread a lot more than I think was necessary. If we had
I'm sorry to interrupt. We need to get all our rounds of questioning. We're well over on that 6 minutes. And for the witnesses, we now go to a 5-minute round of questions. And the first questioner will be Mr. Melillo for 5 minutes. Go ahead, please.
Thank you very much, Mr. Chair. I just want to start with Grand Chief Seti. As I understand, you had an additional comment you wanted to make, but you weren't able to. So I actually just want to give you the opportunity to add that comment if you'd like to.
Thank you very much. I appreciate that. I just wanted to conclude our discussion how COVID-19 has brightly illuminated the gaps and barriers and the urgent need to uphold the rule of law. And the COVID-19 pandemic also highlighted important opportunities to amend federal, provincial, and First Nation legislative frameworks to recognize and develop the capacity of First Nations. First Nation enforcement and justice officials and First Nation lawyers need to make and enforce and prosecute and adjudicate First Nation bylaws and laws. So that was what my concluding statements would have been. Thank you.
Thank you. And now that I have you on the hot seat, I'll ask you a question as well. I if I was understanding correctly, and please correct me if I am wrong, part of the issue that that your organization sees is that that First Nations safety officers aren't considered peace officers when enforcing band bylaws. So I'm just wondering if you could speak into a little more detail into that, on sort of how that that framework, for lack of a better word, impacts the day-to-day for the safety officers.
Thank you so much. Can I defer this to Mike Anderson, who's been working on that file, please? Thanks.
Thank you for your question, and thank you very much, Grand Chief. The First Nation safety officers that we had today originated as band constables under the former First Nation, the Public Safety Canada Band Constable Program in and around 1965. So they've been providing first responder, and in some case, the only responder, public safety services in our remote First Nations, particularly for all that period of time. Between the onset of the program and the repeal of the Provincial Police Act in Manitoba, June 1st, 2012, in their later years, they had the powers and protections of a peace officer to do their duties. With the coming into force of the Provincial Police Act in Manitoba, effective June 1st, 2012, their peace officer authority was limited to only prescribed provincial enactments, and not even all of those enactments. So there was no clear authority for them to act as peace officers to enforce band bylaws, which became quite an issue. Similarly to the discussion on land code laws, RCMP officers would say that the First Nation safety officers didn't have authority to enforce their band bylaws. Eventually, the operating agreement was amended, not the statute, but the operating agreement was amended to recognize peace officer authority only when enforcing an 81.1c bylaw, which is the observance of law and order. And of course, 81.1a is the prevention of spread of infectious diseases and so on. So Grand Chief Settee firmly presented to Minister Friesen that we needed to have clear peace officer authority for our bylaw enforcement officials in order to enforce the full suite, the robust suite of authority under 81.1 and 85.1 in particular. The government has just within the last 2 weeks, Manitoba, agreed to amend the safety officer operating agreements to make it clear that they have peace officer authority when they're enforcing all band bylaws. And we pointed out that that was necessary so that when the protocol is rolled out in Manitoba, which is happening today, by the way, there's a press conference after this session, then it'll be clear that the safety officers have full authority to enforce band bylaws. For the first time since the dissolution of the Band Constable program in 2015. Essentially, as I had mentioned in my comments, you have to have a peace officer authority to stop, search, seize, and detain. And under Section 103 of the Indian Act, only a peace officer can seize goods related to a violation of an 81.1 or an 85.1 bylaw, including an intoxicants bylaw. So if a First Nation safety officer is seizing alcohol, they have to be a peace officer. It's required by the Indian Act. So we wanted to bring all of this into alignment so that the actual duties they provide are protected. I'd also point out that the former D Division Commanding Officer, Bill Robinson, described the role of our band constables at the time as first responders in the absence of the RCMP. So they were actually providing a policing function in the often extended absence of the RCMP, who only serve some of our communities on periodic patrols that might be monthly, and they're there the rest of the time. So it's essential that they have the proper authority to do their jobs and to uphold and enforce the law.
Thank you. I'm surprised that our recommendations are being put into effect before we've even finished the study.
Well, I would just add, Mr. Chair, that that's Grand Chief Satie's insistence and his personal relationship with the Justice Minister of Manitoba, Cameron Friesen. We've been able to collaborate very closely with them in open and frank dialogue, and they heard Grand Chief clearly, I'm happy to say.
Thanks so much. Pam DeMoff, 5 minutes.
Thanks, Chair. And I'll just start by acknowledging that I'm on the traditional territory of the Mississaugas of the Credit First Nation here in my riding of Oakville, North Burlington. Chief Louis, if I'm not mistaken, the pilot you mentioned is dealing with environmental protection laws, and we haven't heard a lot or anything about that. I wondered if you could maybe talk a little bit about that pilot.
Thank you very much, Mr. DeMoff. I wonder, this is the question I would like to defer over to my colleague Andrew Bynan, if that's all right. He's been working. That's fine. He's been working quite a bit on this.
Yep.
Thank you.
Well, thank you, committee members, and thank you for the question. The Saskatchewan pilot project led by Whitecap Dakota and Muscogee First Nations is really quite interesting. And as Chief Louis mentioned, we'll be holding part of our national online conversation, a recorded event at which MPs, the public, federal officials, First Nation officials, provincial officials, everyone is welcome to register. And so individuals who are directly involved will be speaking to what they are achieving right now tomorrow. So I don't want to take away too much of their thunder. But having said that, I would offer 2 points. One, there is a lot of work somewhat similar to this issue of First Nation safety officers in the pilot project. In Saskatchewan, they're referring to them as community safety officers, and trying to work out with clarity the scope of their authority to enforce the First Nation laws of Muscogee and Whitecap Dakota, and to work in partnership with provincial authorities. In terms of environmental issues, I know that there has been concern expressed, particularly at Whitecap Dakota Nation, which is very close to the city of Saskatoon, with environmental issues that affect the community. They have direct experience with situations where some individuals were carrying on businesses on the lands, which really caused significant contamination to reserve land. And unfortunately, at least one of those situations was very difficult to control. And rather than be prevented from happening, the environmental damage occurred on the lands, and the Department of Indian Affairs, as it then was, provided some assistance to deal with the cleanup of the toxic damage on reserve lands. So this was a failure of the enforcement of laws, a failure of being able to control and avoid environmental harm. And we could ask Whitecap Dakota First Nation to follow up with you if you're interested.
Yeah, I was actually going to ask, since your meeting is tomorrow, perhaps they could just submit something to the clerk so we could include it in the report.
Indeed.
And then Chief Bill, it's nice to see you again. Obviously, your community safety officer program is a model for the country, and as my colleague Gary Vidal mentioned, you've come to Public Safety Committee, and I know you're doing a terrific job. I think all of us sat horrified at what Chief Denny talked about with, going 20 minutes, half an hour before police arrive on the scene of a loved one, and he's forced to go there. So, Chief Bill, I guess your community safety officers would not be responding to a situation that he described with gunfire. You would still be relying on the RCMP. So, where is the disconnect between his experience in his community and what you're experiencing at Kwanlundun?
Well, I think with the CSOs, they don't have enforcement power.
Hard to hear you, Chief Bill.
Oh, sorry.
That's better.
I was drinking coffee. The CSOs don't have enforcement power, and when we surveyed our citizens recently, they didn't want them to have enforcement power, and it was interesting because I think otherwise that trust would dissipate. And
so do you experience the same issues that Chief Denny described?
We do. And what happens with us, because we're right in the city of Whitehorse, we're a small enough community, the RCMP do respond very quickly to those kinds of incidents. However, the CSOs work alongside the RCMP. For instance, if a murder happened or something of that nature, the RCMP would focus on what they have to do, and the CSOs would focus on the community, keeping the community away, keeping the area cordoned off, keeping the area safe.
Mental health supports for the family too.
Yeah,
probably.
and they ensure when the RCMP go, there's often a gap between the services, between the community and the RCMP. The CSOs ensures that, let's say, if a woman was sexually assaulted, for instance, they would get that the services that they need, the culturally relevant services that they need. And the trust between the RCMP and, the RCMP and the CSOs has really improved. The RCMP were very, very skeptical in the beginning, but now they see the value in it, and they are one of our highest recommendations when we talk about these services.
Thanks, Chief.
Yeah.
We're well over time, and we'll move to Madam Beyroubé, 2.5 minutes.
Merci, Monsieur.
Thank you, Mr. Chair. My question is for Chief Louis. In your brief, you recommend to designate the Attorney General as responsible to deal with the enforcement issue. What are the changes that would happen if that happened?
Thank you very much, Honorable Member. We believe that the changes would be more immediate, more urgent, with the Attorney General directly involved. This is the ministry with perhaps the highest recognized designation, and I think would command a lot more immediate attention, particularly as other Attorney Generals from each of the provinces are concerned, and as a matter proceeds. So that in itself, we believe, gives a lot more credibility, more urgency to the situation. And that's what we would hope to achieve by having the Attorney General directly involved at that level.
Can you tell me what are the recommendations that you put in your brief? So, according to you, what are the recommendations that are an absolute priority?
Thank you. We have several recommendations, of course, and they're all, I suppose, in our opinion, equally important. I mean, having the Canada Indigenous Justice Strategy include express commitment to tackling the enforcement of laws as a short-term priority is important. The federal Attorney General is the lead minister, of course, responsible for leading the federal government's commitment is important. Having the various departments and agencies requiring a strong lead at the bureaucratic level, and the appointment of ministerial representatives or senior bureaucrats with credibility on these matters is significant. Matrimonial real property laws require special consideration by Canada for the goals of protecting women and children. This is very, very significant. The Indian Act legacy of environmental mismanagement and the understanding that it is woefully unregulated, under-enforced, and having support for enforcement of First Nation environmental laws within broader strategies in environmental management concerns is absolutely critical. There is so much contamination that's taking place. This is a high area of concern and needs immediate attention.
I should leave it right there. I'm sorry we have to move along to Ms. Blaney for 2.5 minutes.
Thank you. And if I can come back to you, Chief Bill, remember to put your thing down. You talked about having 4 full-time CSOs and 2 on call. I just have a couple of questions. Do they patrol 24 hours a day? How do they manage the collaboration between the RCMP? And you indicated that they fill in a specific gap between the RCMP and the community needs. You talked about that a little bit, but just how do they manage that? What sort of mechanisms do they have to make sure that that relationship, which sounds is very collaborative, be successful?
What we did in the beginning was we got real-time statistics from the RCMP from bylaw, and we really analyzed those statistics and figured out when the peak hours were in our community. And the CSO's hours are built around those times. And we review it every now and then as well. In terms of the RCMP and the relationship with the CSOs, that relationship really, we had to figure out a way to build that relationship. And the best way to do that was to just work alongside of them. We were there, whenever things happened. I think they just watched our CSOs and really, as our people began to gravitate towards them when serious things happened, they understood that, hey, there's something here. And we don't have any formal agreement or anything with the RCMP. We do have formal meetings with them through the letter of expectation. We sit down with the RCMP once a month. We also have different meetings through the interagency working group, and we work out any issues that arise through those avenues. And the relationship I've watched with the CSOs just blossom. It's absolutely wonderful. And the RCMP now will call on our CSOs when their issues arise and they need help from our citizens when they're looking for someone or something of that nature.
Thanks so much. And Mr. Schmale, we have you for 5 minutes.
Thank you very much, Chair, and amazing conversation today. I'm actually, there's just been so much content here. Maybe I will pick up with our friends at the First Nations Lands Advisory Board. We were talking about the Indian Act and the hurdles to in some cases life and safety on reserve. Maybe we can talk a bit more about that in terms of if that were to be scrapped, what if anything would be replaced in its place, or what would need to come in to ensure a smooth transition?
Andrew, would that be something that you'd want to tackle first?
Well, maybe if I can just get a bit of clarification on the question. I would start, though, by saying this. Land code laws assist in driving and supporting safety in the community. So by dealing with trespassing, by dealing with problematic situations on reserve, overall community safety can increase. In the absence of enforcement systems, in the absence of a police response, in the absence of being able to find prosecutors, you have damage to the rule of law. And as many of the witnesses have spoken about today, when you have a breakdown in the rule of law on issues like trespass or matrimonial real property and violence and illegal dumping and disrespect for the law, it has a corrosive effect in terms of abiding by federal and provincial laws. And I would suggest it makes it more difficult for the RCMP and other police forces to uphold the rule of law in respect of federal and provincial laws. So I would suggest that what a lot of the witnesses have offered and many of the submissions to this committee underscoring the importance of immediate action to solve this issue of enforcement of laws. It's not only a matter of improving the respect for and compliance with First Nation laws, but it'll have positive consequences beyond that in upholding the rule of law of Canada.
Okay, perfect. Thank you very much for this. My second question, I don't know who to direct it to, so maybe I'll just kind of look in my screenshot here and see whoever puts up their hand. A number of potential solutions to the enforcement and the policing issue on reserve, and it's worked in many cases quite well in parts of Ontario, is the restorative justice aspect. And I don't know if there's anyone that would like to say a comment to that, and I'll kind of look to, oh, I see our friends from the, okay.
Yes, just very briefly, it's an excellent question. Restorative justice is an approach which involves healing within the community and a focus on trying to resolve harm that has been caused. And it very much often reflects the culture and traditions of individual communities. And there's no doubt that this is extremely important. At the same time, a lot of what witnesses and submissions have dealt with is what I might call conventional or mainstream Western justice, which focuses on offenses, policing, prosecutions, and punishment. What I would suggest to the committee is that in order for restorative justice to thrive, there has to be, at the same time, an avenue to dealing with conventional punishment-oriented justice available to First Nations as well. Unfortunately, if some individuals think they can get away with ignoring First Nation laws, they're probably going to ignore restorative justice efforts as well. The last quick comment I would make about restorative justice is to say it can work in partnership with the Western legal system. If there's a well-understood, well-established system for policing, prosecution, and going to the conventional courts, those judges have access, working with First Nation partners, to restorative justice approaches. Maybe it's better not to punish an individual, but instead to offer them an avenue to restorative justice and healing. But without an effective conventional system, too many individuals will thumb their noses at compliance with the law, whether it be through a restorative justice approach or a conventional approach.
Thank you very much. And that takes us to Mr. Pawlowski for 5 minutes.
This has been a very interesting study. We've seen this unanimity of all chiefs from across Canada agreeing that it's been very difficult / impossible to try to enforce bylaws related to trying to impose public health measures and control of COVID. And yet in response, we see really a patchwork of approaches. Some chiefs preferring to use bylaws under the Indian Act, others the First Nations Land Management Act. PPSC entered into agreement with some First Nations in order to try to enforce the bylaws. Manitoba today's talked about, I believe, a protocol to enforce bylaws under the First Nations policing program. Chief Bill has CFO program. So we see like every community has a different response. And Chief Bill said each community is different, which is true. And I think many would say it's colonialism to impose solutions, that each community has to come up with its own approach to its problems. But I have to ask, what do all of our witnesses say to this? Because is it realistic for a community of 300, 400 people in order to come up with a system of law enforcement, to come up with a system of dealing with their water problems, their transportation problems, their housing problems? So is the answer to this problem of enforcement of laws in First Nations, should it be a global solution for the whole country, or should this be a solution that's particular to each community? So that's one thing. And then the second, I think Chief Louis has stated that the use of the Indian Act is offensive. He doesn't want to use that. However, I would suggest that under Section 107 of the Indian Act, there is a process to appoint justices of the peace to enforce bylaws made under the Indian Act. And although that may be offensive, I would suggest the process of lawmaking is slower than continental drift. So it's going to take a fairly lengthy period of time in order to change the laws on policing. Wouldn't it be better perhaps to use the existing laws, reinstitute the Section 107 courts? So I throw that out to all of you. Whoever wants to start.
Mr. Pawlowski, if I may, it's Robert Louie. I want to maybe just refresh people's thoughts here with regard to the force of law, with regard to land codes. And of course, we represent our constituents who are self-governing, and to look at the Indian Act, to rely on the Indian Act, any of the sections for governance is quite offensive. So in our land codes and the way the legislation was set up by Parliament to recognize our communities as self-governing First Nations, I remind you of Section 15 sub 1 of the Land Code, which says that the laws as a force of law and judicial notice shall be taken of the Land Code in any proceedings from the date the Land Code comes into effect. That's very significant. And also, it's coupled by Section 20 sub 1 of the Land Code legislation, which says that it may provide for enforcement measures consistent with federal laws, such as the power to inspect, search, and seize, and to order compulsory sampling, testing, and the production of information. And of course, the Justice of the Peace Clause, Section 24 sub 1, which says that we may appoint Justice of the Peace to ensure enforcement of First Nation laws, including adjudication of offenses for contraventions of First Nation laws. So my point is that we have the authority. It was recognized by Parliament. What is lacking is the direction to all of the various ministries, to the provincial governments and so forth, that these laws are valid and they must be recognized. So when laws are put in place, it's a matter of education and simply, I think, in many respects, informing the policing authorities that you must respect this. There's paramountcy in the federal law, which this now has. So I think this is very important. So for us to rely on something that we do not have to rely on, especially under the Indian Act, is not acceptable to our land code self-governing communities.
Chief, thanks so much. Members of the committee, we will have to suspend to do some business in camera with regard to other matters of the committee. And so I think in view of that, I'm going to thank our committee members, thank our witnesses and our committee members, because it's been just an excellent give and take and cross examination and really impressive. You know, witnesses, I wish that more Canadians could hear the kind of presentations that we're hearing as committee members, beyond the simple confrontations at blockades when there's anger and misinformation going on. I mean, it's so impressive to hear the points of view, the studied points of view, rather than the simple, darn it, why is this happening situation that is beloved of the media, but really doesn't help sometimes to move issues forward. So I want to thank you all for that very valuable testimony. And I'm going to ask for a suspension as we leave the meeting and then come back again to reconvene as in camera. So thanks to everybody once again. This meeting is suspended.
Bye.